Welcome back to LexTalks, Legal Topics Simplified, where we try to break down these complex legal concepts, especially for you guys, all of you amazing law students out there in India. And today we're going to be doing a deep dive into something you'll be seeing a lot throughout your studies, writs.
Absolutely. Writs are they're really essential for understanding how, individuals can actually seek justice from the courts, especially when their fundamental rights are at stake.
Okay, so I was going through, a lot of the material for this episode and academic papers, articles, judgments, all sorts of things. And it seems like, writs are basically like these legal tools, right? Like a direct line to the higher courts. They let individuals petition the Supreme Court or the high courts directly when they feel like, their rights have been violated.
Yeah, that's a great way to put it. They're a very powerful way to ensure that your voice is heard when it matters the most. And it's interesting. You might be surprised to know that these legal tools actually have a very long history, going all the way back to English common law, and they were adapted for use in India even during the British Raj.
Wow, I did not realize they had such deep roots.
Yeah.
But what makes them so powerful in the Indian context specifically?
Well, for that, you have to look at Article 32 of the Indian Constitution. It's really the bedrock of writ jurisdiction in India.
Okay, Article 32, that's the one that guarantees the right to move the Supreme Court for the enforcement of fundamental rights, right?
Exactly. And what's really fascinating here is that it makes the remedy itself, meaning the right to actually seek these remedies, a fundamental right. So that's a major distinction from other legal remedies.
So it's not just that you have fundamental rights, but you also have the fundamental right to actually go to the Supreme Court if those rights are violated. That's pretty powerful.
It is. It has really significant implications because of that, the Supreme Court cannot refuse to hear a writ petition if it relates to the enforcement of fundamental rights. It's not something they can just ignore.
That makes sense. But what about the high courts? They can issue writs too, right?
Yeah.
So how does that all work? Is it the same process?
Yeah, so both the Supreme Court and the high courts have the power to issue writs, but there are some important differences to keep in mind. We can break it down into three key areas: scope, territorial jurisdiction, and discretion.
Okay, let's unpack those one by one. First up, scope. What's the difference in scope between the Supreme Court and the high courts?
Well, the Supreme Court's writ jurisdiction is specifically limited to the enforcement of fundamental rights. That's where Article 32 comes in. High courts, on the other hand, have broader powers. They can issue writs for other purposes as well, beyond fundamental rights.
Interesting. So if your case involves a fundamental right, you could go directly to the Supreme Court, but for other matters, you might have to start at the high court level.
Precisely. Now, territorial jurisdiction is fairly straightforward. The Supreme Court, naturally, has jurisdiction all over India, whereas high courts are limited to their respective states.
Right, right. It wouldn't be very practical for every single case to go straight to the Supreme Court.
Exactly. And finally, we have discretion. This is where things get a bit nuanced. The Supreme Court, because of Article 32, must exercise its writ jurisdiction for fundamental rights cases. They can't refuse to hear a case that falls under that article. High courts, however, have a bit more leeway. They can, in certain cases, choose not to exercise their writ jurisdiction.
So there's a bit more flexibility built into the high court system. Okay, I think I'm starting to get the big picture here, but we've been talking about writs in general. Let's get down to the specifics. What are the different types of writs? I think you mentioned some Latin terms earlier.
Ah, yes, the Latin terms. Don't let them intimidate you, though. They're just fancy names for different tools in the legal toolbox.
There are 5 main types of writs that you should know: Habeas Corpus, Mandamus, Prohibition, Certiorari, and Quo Warranto.
Okay, that's quite a list. Let's break them down one by one, starting with habeas corpus.
Okay, so habeas corpus literally translates to produce the body. This writ is used to challenge unlawful detention. So think about it. Someone is being held prisoner, without a legitimate reason, or maybe even being held beyond the legally permissible time. Habeas corpus is their way to demand their freedom, to force the authorities to bring them before the court and actually justify their detention.
It sounds like a crucial safeguard against arbitrary detention, especially given some of the stories you hear about people languishing in jails for years without trial. Absolutely, and you're actually touching upon a very significant point here. There's a famous case in India, which we won't name explicitly, but it's often referred to as the Husainer Khatun case. It dealt with the plight of under trial prisoners and the excessive delays that they were facing in the legal system. And habeas corpus was a key tool in that case, not just to, secure the release of individuals, but also to force the courts and the government to actually confront these systemic issues that were, present within the prison system.
So it's not just about individual cases. It's about using habeas corpus to push for broader reforms and systemic change.
Right. You got it. Now let's move on to Mandamus, which, if you break it down, it essentially means we command.
Eat it, Mandamus.
Yeah.
We command. That sounds like a pretty authoritative writ.
Yeah.
What's its purpose?
So it's used to compel a public authority to perform a legal duty that they're neglecting. So imagine a scenario where a municipality is failing to address, a serious pollution problem in a local river. Despite having this legal obligation to protect the environment, Mandamus could be used by concerned citizens to force that municipality to take action, to actually do what they're supposed to be doing.
So it's like a legal tool to hold the government accountable, to ensure they're fulfilling their duties and responsibilities to the public.
Precisely. It's a way to make sure that the government is actually serving the people, not just ignoring their legal obligations.
Got it. Okay, so we've covered habeas corpus and mandamus. What about the other three?
So the next two, prohibition and certiorari, are a bit more technical, but they're essentially about judicial oversight. Prohibition is used to prevent a lower court from exceeding its jurisdiction. It's essentially saying, you're overstepping your boundaries, stop right there. And then certiorari is used to review a lower court's decision, kind of like saying, let's take a closer look at what you decided and see if it was actually correct.
So those are all about, making sure that the courts themselves are functioning properly, that they're not overstepping their bounds, and that their decisions are being reviewed.
Yes, it's a system of checks and balances within the judiciary itself. And finally, we have Quo Warranto, which is a fascinating one. It's used to challenge the legality of someone holding public office.
Quo Warranto, that sounds like it could make for some pretty dramatic legal battles.
It certainly can. Imagine a situation where someone is occupying a position of power, maybe a government official, maybe even someone, heading a public institution, but they're not actually legally entitled to be there. Quo Warranto is that legal weapon that can be used to challenge their position, to ask, by what authority are you holding this office?
So it's a way to ensure that those in power are actually legitimate,
Yeah.
that they have the legal right to hold the positions they do.
Exactly. It's all about accountability and transparency, making sure the system is functioning as it should and that power isn't being misused. Now, before we move on to the next segment of our deep dive, we need to talk about a concept that's closely tied to writs, especially in the Indian context. Public Interest Litigation, or PIL for short.
PIL, that's a term you hear a lot these days, especially in cases dealing with social justice and human rights. But how does it relate to writs specifically?
Well, PIL is all about expanding access to justice, making it easier for people to use writs to address issues that affect the wider public.
I'm all ears. Tell me more.
So before PIL came along, you basically had to demonstrate like a direct personal injury to file a writ petition. You had to show that you specifically were harmed by the action or inaction of the government or another party. But PIL really changed the game.
Okay, so how exactly did PIL make it easier to file writ petitions?
Well, it relaxed the rules of locus standi, which is, the legal term for standing. The right to actually bring a case before the court. PIL allowed individuals and organizations to file writ petitions on behalf of, larger groups, even entire communities, even if they themselves weren't directly affected by the issue.
Oh, wow. That's a pretty big shift.
Yeah.
So you no longer had to be like the direct victim to actually seek justice. You could step up and advocate for others who might not have the means or the knowledge to do so themselves.
Exactly. This was a huge win for marginalized communities who often face, systemic barriers when it comes to accessing the legal system. PIL really empowered them to challenge these injustices that might have otherwise gone unaddressed.
That's incredible.
Yeah.
It's like using writs to actually level the playing field and give a voice to those who might otherwise be silenced.
That's a great way to put it. And this shift in locus standing was a major catalyst for what we call judicial activism.
Ah, judicial activism.
Yeah.
That's a term that often sparks a lot of debate, but how does it tie into PIL and writs?
Well, judicial activism is, in essence, about courts actually stepping up to address societal issues, even if it means, going beyond a strict interpretation of the law. And writs, particularly through PIL, became a key vehicle for this activism.
So judges weren't just like passively applying the law. They were using writs, empowered by this broader concept of locus standing to actually shape the law and address these pressing social problems head on.
Precisely, PIL and judicial activism kind of working hand in hand led to some landmark judgments that have had, a lasting impact on Indian society.
Faye, I'm eager to hear about some of these groundbreaking cases. Give me some examples.
One area where PIL has had a really profound impact is environmental protection. So in the past, environmental laws were often very poorly enforced. Industries could pollute with impunity, and the government was, often very slow to act. But PIL changed all that. Activists and concerned citizens empowered by PIL could go directly to the courts and demand action. They could force industries to clean up their act, protect forests and rivers, and really hold the government accountable for environmental damage.
That's incredible. So it wasn't just about, individuals seeking redress for some personal harm. It was about using PIL and writs to actually protect the environment, something that benefits, everyone, even future generations.
That's the power of PIL. And it wasn't just limited to environmental issues. Remember that landmark case we talked about earlier about under trial prisoners? That was also a result of PIL and judicial activism. The court didn't just order, the release of those individuals. It used its writ jurisdiction to push for these systemic reforms in the prison system to ensure that such injustices wouldn't happen again.
Wow. So these cases weren't just about, winning for the individual petitioners. They were about using writs to achieve these broader social justice goals,
Right.
to create a more just and equitable society.
Exactly. And that's what makes PIL so fascinating and at times so controversial. It has really empowered the judiciary to play a more active role in shaping society, which has led to some truly groundbreaking advancements.
But I imagine there's a flip side to this as well, right? I mean, giving courts so much power, even with, good intentions, could potentially lead to problems.
You're right. There are valid concerns about judicial overreach, about, courts potentially stepping on the toes of the legislature and the executive branches of government.
So how do we balance this? How do we ensure that the judiciary, while empowered to, protect rights and promote justice, doesn't become too powerful or stray too far from its, traditional role?
It's a delicate balance. And there are these ongoing debates about, the limits of judicial activism and potential downsides of PIL. Some critics argue that PIL can be misused, leading to frivolous litigation and just bogging down the courts with cases that might be better addressed through, other means.
So it's like any powerful tool. It can be used for good, but there's always a risk of it being misused or having these unintended consequences.
That's a great point. And it's something that legal scholars and practitioners continue to, grapple with. How do we harness the power of PIL and writs for good while also guarding against their potential misuse? It's a question that doesn't have easy answers.
Okay, so there's a lot to unpack there.
Yep.
We've talked about the power of PIL to expand access to justice, to fuel judicial activism, but we've also acknowledged that there are these valid concerns about potential overreach and misuse. What I'm taking away from this is that PIL, like any legal tool, really needs to be used responsibly and with a clear understanding of its potential impact.
Well said. And it's important to remember that the evolution of PIL and writs in India is an ongoing process. The legal landscape is constantly shifting, and how these tools are used and interpreted will continue to shape, the future of our legal system.
This deep dive has been fascinating. We've covered so much ground from the historical roots of writs to the complexities of judicial activism and the ongoing debates surrounding PIL. Before we wrap up, I'd love to get your perspective on how India's approach to writs compares to other countries. I know you mentioned the UK and Pakistan earlier.
It's a great question, and it helps to broaden our understanding of how different legal systems approach these, similar challenges. As we discussed, India's writ system is deeply rooted in English common law, so the UK is a natural point of comparison. While there are, fundamental similarities in the types of writs and their basic functions, the way they've evolved and the specific challenges they face differ based on the unique, social and political context of each country.
Can you give us an example of some of these differences?
Well, in Pakistan, for instance, the military's exemption from writ jurisdiction has been a major point of contention. It raises questions about, accountability and the rule of law when you have these certain powerful institutions that are that are placed outside the reach of judicial scrutiny. And in the UK, they've had their own struggles, particularly when balancing individual rights with national security concerns, especially in the context of terrorism.
So even in countries with these long-established legal systems, these fundamental questions about, the power of the judiciary, the limits of legal remedies, and the balance between individual rights and national security, they remain, hotly debated.
Absolutely. And the way each country answers these questions really shapes the evolution of their legal systems and the role of writs within them.
It's fascinating to see how similar legal concepts can be, interpreted and applied so differently depending on the context. Okay, so we've explored the big picture of writs, their history, their evolution, and even their global context. Now let's zoom in on a specific writ that seems to be, particularly relevant to our discussion of judicial activism: Quo Warranto.
Ah, yes, Quo Warranto, the challenge to power. It's a unique and powerful tool. As we briefly discussed earlier, it allows the courts to actually question the very legality of someone holding public office.
It's like a legal show me your credentials moment,
Yeah.
but with much higher stakes.
Exactly. And its use in India has a fascinating history with evolving interpretations and applications that really reflect the changing dynamics of our legal system.
Okay, I'm ready for a deep dive into Quo Warranto. Give me the highlights. Okay, so Quo Warranto, it's all about challenging the legitimacy of someone holding public office, right?
Wow.
And you mentioned it can get, pretty dramatic. What are some of the nuances in how it's applied?
Well, one key thing to remember is that Quo Warranto isn't just about challenging the initial appointment or election.
Yeah.
It can also be used to question someone's continued right to hold that office, even if, their initial appointment was perfectly valid.
So it's not just a one-time check at the beginning. It's like an ongoing safeguard to make sure that, someone who might have been eligible initially doesn't continue to occupy a position that they're no longer legally entitled to hold.
Exactly. Let's say an elected official is convicted of a serious crime while in office. Quo warranto could be used to argue that their conviction, disqualifies them from remaining in that position of power.
That makes sense. I mean, you wouldn't want, someone convicted of corruption, for example, to continue making decisions that could potentially impact, public resources or governance.
Precisely. And it's not just limited to criminal convictions. Imagine a scenario where there are, specific eligibility criteria for a public office, perhaps an age limit or a residency requirement. If someone no longer meets those criteria, Quo Warranto could be used to challenge their continued occupancy of that office.
So it's a way to ensure that those in positions of authority actually meet, the ongoing requirements of their roles, not just the initial qualifications they might have had.
Yes, and what makes Quo Warranto cases even more interesting is that, they often involve these complex legal questions. It's not just about proving, simple facts. It's about really diving into the intricacies of legal interpretation. You might be looking at statutes, constitutional provisions, even historical precedents, and arguing about how they apply to the specific situation.
It sounds like these cases can become, quite the battle of legal wits, with lawyers on both sides, carefully dissecting legal texts and building these elaborate arguments.
It can be quite fascinating to observe, and remember, judicial activism plays a significant role in these Quo Warranto cases as well. The way courts choose to interpret the law to balance these competing interests and apply precedents can have a huge impact on the outcome.
It's a good reminder that judges aren't just, robots blindly applying the law.
Yeah.
They have to make these judgment calls, interpret ambiguous language, and apply legal principles to real-world situations that might not have been anticipated when the laws are written.
Absolutely. To really grasp how Quo Warranto works in practice, let's look at a couple of examples without, of course, naming any specific names.
Okay, I'm ready for some real-life legal drama. Give me the highlights.
So in one notable case, Quo Warranto was used to challenge the appointment of a high-ranking official in a government agency. The petitioner argued that the individual lacked the required qualifications and experience for the position, and that their appointment violated these established procedures.
So it wasn't just about, whether they were qualified on paper, but whether the process of their appointment, actually followed the rules.
Exactly. And in this case, the court ultimately agreed with the petitioner and declared the appointment invalid. It showed that even these, high-ranking appointments aren't above legal scrutiny.
That's a big win for accountability and transparency in government.
It was a significant judgment. In another case, Quo Warranto was used to challenge the election of a member of parliament. The petitioner alleged that the individual had engaged in electoral malpractice, including voter intimidation and bribery. And this time, the court really had to sift through evidence, hear witness testimonies, and really delve into the details of what happened during the election.
It sounds like a very complex and potentially messy process. What was the outcome?
Well, after a lengthy trial, the court found the allegations to be true and declared the election void. It was a powerful demonstration of how Quo Warranto can be used to uphold the integrity of our democratic processes.
So even those elected to the highest offices aren't immune to these legal challenges. Quo Warranto ensures that nobody, regardless of their position or power, is above the law.
Precisely. These cases demonstrate how Quo Warranto really serves as a crucial mechanism to safeguard our democracy and hold those in power accountable for their actions. It's a vital tool in our legal system.
This has been an incredible deep dive into the world of writs. We've covered so much ground, from their history and types to the nuances of judicial activism and the power of PIL. But before we wrap things up, is there anything else our listeners should keep in mind as they delve deeper into this fascinating area of law?
I think the key takeaway is that writs, while powerful legal tools are just one part of a larger ecosystem, they operate within the framework of our legal system with its own complexities and constraints.
So it's not just about knowing the legal principles, but also understanding how they actually play out in the real world with all its nuances and challenges.
Exactly. And while we've focused on how writs can be used to challenge the powerful and hold them accountable, it's equally important to remember that they can also, empower individuals and communities to fight for their rights and bring about positive social change.
So writs aren't just about taking down the powerful; they're about giving a voice to the powerless. That's a powerful message to end on.
Indeed. The pursuit of justice is an ongoing process, and writs in the hands of those who understand their power and potential can be a real force for good in society.
Well said. This has been an incredibly insightful discussion. Thank you so much for sharing your expertise with us today.
It's been my pleasure.
And to all our listeners out there, thank you for joining us on LexTalks. We hope you found this deep dive into the world of writs informative and engaging. Be sure to follow, subscribe, and stay connected for future episodes where we break down more fascinating legal concepts. Until next time.